The legal analyst Elton Hart now from the University of Johannesburg's Law Clinic joins us live via video link to look at the processes of investigation and interrogation regards to law enforcement authorities in South Africa. We're going to be looking at the rights of suspects and responsibility of investigative officers to prove a watertight case with admissible evidence as well. Elton Hart, on that note, good afternoon. Thanks for joining us on the SABC at this hour.
Good afternoon, Liesl, and good afternoon to the viewers.
So let's start off with what's unfolding with regards to the AKA and Tibbs case. Just looking at the latest postponement and the extradition process as well, having been filed and now also granted, the bearing that all of this has on the case at hand as we start there.
Now, obviously, once we look at it and we say that the NPA, together with the Minister of Justice and the DIRCO, who is responsible for actually submitting papers to the Eswatini authorities, the National Prosecuting Authority, have to submit the papers. Then a hearing takes place in Eswatini where they now make a decision as to will the rights, the fair trial rights of these two brothers, the Ndemandi brothers, be adhered to when they are delivered or deported back to South Africa so that they can stand trial for an alleged offense that they committed in South Africa. Once that is in order, they are extradited, then obviously the court now has the opportunity to actually put them through the paces where it needs to be the bail application and all those things. But that is normally first before the Eswatini court has to say that, okay, now we make a ruling that these guys be handed over to South Africa. Then that extradition process can actually be executed now by the Royal Eswatini Police and hand them over to the South African Police Service.
Thank you for clarifying that, because now as we look at the process of investigation to acquire and also prove a suspect guilty of a crime, talk to us about that, and also at this juncture how watertight the case is given what's unfolding.
Now, obviously, I believe there's still a lot of investigative work that needs to happen, but obviously the rights of the accused, one needs to always bear in mind that Section 35 of the Constitution sets out the rights of arrested, detained, and accused persons in any offense. So you need to adhere to the Constitution when dealing with these people or with persons that's in conflict with the law. And also the Criminal Procedure Act sets out also procedures. And obviously when police go about their investigative work, they should do it in line with the Constitution. They cannot violate any right in the Constitution to gather evidence. So like we heard in the Senzo trial, they were talking about tubing and beating up people. We're not saying it's true or not true, but police should refrain from that behavior. They are not allowed to actually coerce or induce a person into making confession statements or giving them information. They have to just interrogate, and interrogate means just like you and me, Liesl, having now a conversation. They should just pose their questions. Do you know about this? Confront them with evidence, but not using physical force to actually make them remember certain things, if I can use that word loosely.
Well, thank you for touching on the allegations of police coercing suspects into confessions and really the impact that has. We've seen it now come through as sentiments in this case and also the Senzo case. The suspects themselves, talk to us about what constitutes one as a suspect if an investigation is unfolding, the importance of following that legal procedure that you spoke about when investigating a crime, and there's wind, already a suspect in the wind. Also, once a suspect is apprehended, what are their rights once they have been flagged as people of interest in an investigation? Unpack that for us.
Obviously, if you are flagged as a person of interest in an ongoing investigation, the police will normally call you in for an interview, and they will interview you. And that interview needs to comply with the Constitution. Now, we've heard rumors and reports that police would put people in dark rooms, they would do certain things. I'm not saying that that happened or didn't happen. I was not there, but that should never happen where you are sort of half forced, or maybe they threaten to say that we'll kill you or we'll harm you or your family members. They should just place questions to say, listen, yeah, an incident happened and there's an eyewitness that says they saw you and they saw you doing 1, 2, 3. And if you want to answer, you can answer that. You also have at that point in time, you have the right not to incriminate yourself and say, listen, yeah, I don't feel comfortable answering this question. I want you to get my legal representative. Can you give me my phone call so I can call my legal representative so that they can tell me, am I allowed to say this? Because we know in the Constitution, an accused person or a person of interest doesn't they have the right not to self-incriminate them. And especially if they are not legally trained, more so that they must be cautious when they question these people. And I know sometimes they would keep people a little bit long away from a telephone call and not giving, and maybe the person might crack or speak, but interrogation should not be used to actually exhaust and sort of induce fear or harm into a person of interest or accused to actually give you information that's favorable to your investigation.
Elton, turning our attention from one legal matter to another, the court now having dismissed former President Jacob Zuma's bid to remove Downer from the arms deal case yet again. Talk to us about what's unfolded on that front, and also the matter having now been postponed until the 17th of May for pre-trial conference, really what that now entails from here on to.
For me, it's like simple. One looks at it and we cannot dictate as individuals, as South Africans, we cannot dictate to the prosecutor who the prosecutor should be that's actually presenting their case, because the prosecution is dominus litis. They can choose any prosecutor who's got a proper delegation to actually present their case on behalf of the public, the state, against a person that's accused of committing an offense. We cannot dictate. Now, I see the former president, he brought application after application saying that Mr. Downer harbors maybe ill feelings towards him, and hence he's not comfortable that Mr. Downer harbors that ill feelings. But obviously, the court sitting there as the presiding officer over the matter, they can look at, was Mr. Downer during the course of the trial acting biased or maybe unfavorable or doing unethical things towards Mr. Zuma, and on that basis the court can then maybe make a ruling or they can bring an application. But Mr. Zuma, as it stands now, he cannot dictate to the NPA who should be the prosecutor that prosecutes this case, because the NPA is of the view that Mr. Downer is the strongest prosecutor, knows the case better to actually prosecute the case with the evidence that's available to make sure that the case presents the best possible case, and not to say that they're out and out going to go for a conviction, but just to put the best case before the court to decide if there's a guilty or not guilty verdict.